a very major constitutional sin underlying this whole supposition and context. Well, today, can your lordships proceed on hypothesis upon hypothesis? What would have happened had this happened? But I will satisfy that conscience also. Well, first part of my lordship is
Did you not really?
the governor could have acted on that.
Did you not preclude a consideration of this argument?
I would wish to take your lordships principally to some very interesting underlying juristic principles. Because the lordship have now seen the facts for 2 days, so I'm not going to repeat. Juristic principles which should impel your lordships to decide this matter here and not consider the various options or suggestions of sending it back to the speaker. That's going to be the bulk of my argument. But brothers, I want to start with where we are ending up, because I was here the whole morning and I heard the very important question which fell from the bench, and the Honorable Chief Justice in particular, about the role of the governor. And I'm going to repeat anything. I'm going to try and give a different facet. Well, this is a very unique and a strange case. And I would say from this side, a sorry case, where your lordships has double whammies and triple whammies. Let me explain how. My Lord Mulus put the question of the governor's role. And in one sentence, the question is that if your lordships if the governor found that there is something to be decided by way of unstable majorities, even if you exclude 39, why can't he go and have a trustword, etc., or a decision on the true majorities in the confidence of the House? Well, it's the first thing when you start on that query has been perhaps not given sufficient weight. And the first thing is that your lordship's fundamental rock-solid principle of interpretation of constitution and statutes is that if intentionally a constituent assembly in its amending power of the constitution deletes something, your lordship gives full effect and scope to the intendment behind that deletion. That is axiomatic. It is obvious CUNY, contract or a statute, much less a constitutional amendment, where your lordship's intention is to give effect to that intention.
So para 3 has been deleted.
Now, para 3 deletion is not a small thing. There are debates, there is a SOR, the Constituent Assembly, the Constituent Parliament in its constituent capacity said, look, we must delete it. Why this case is bizarre is that there are at least two circumventions of that deletion directly by high constitutional authorities. Circumvention 1 is clearly this way or that way, whether the governor can do it or not do it, the lordship will decide separately. But clearly and specifically, the governor is acting on a presumption of a split. In whatever way he's acting. Now, as the governor, most of all, is supposed to know the Constitution. All of us are supposed to know the Constitution, and ignorance of the law is no excuse, much less ignorance of the Constitution. There is no system, and I'm not talking of your lordship's narrow question of trustworthy, non-trustworthy. There is no basis on which your lordships can reconcile and harmonize the factual invitation and oath giving on the one hand with the legal deletion of para 3. That's my proposition. The two are irreconcilable. And that is a very major constitutional sin underlying this whole supposition and context. The context of this case can be divided into broadly three or four categories. And that context makes it clear that your lordships need not be bothered about the governor coming into the picture at all. The first phase of this context is the expedient of giving a disabling notice. I call it a disabling notice before I intend to defect. Now, that will be awaiting your lordship's decision on Nabam. So, phase 1 or part 1 of this context is disabling notice. Your lordship must decide in Nabam. That's the whole argument we made for 2 days. But clearly the context is that step 1. And if that is wrong, then a lot of things fall down. And that is wrong in case your Lordship doesn't agree with the literal text of Nabam. The second part is that we are also forgetting repeatedly the object of the 10th schedule. Well, as more than any other jurisprudence in this part, subject of constitutional law, are cases again and again talking of two things: the evil prior to 84, the object of plugging that evil, the mischief rule, and what your Lordship is doing by the 10th schedule. The third is that if your Lordships accepts that the basic object of the 10th schedule is a constitutional sin being precluded or stopped or reduced, then Malus 2-1 A or B, as the case may be, has to be decided first. It's logically prior, Malus, to everything. Not only is it prior in terms of serial number, but conceptually it has to be logically prior to any decision of any kind in any case. I'm talking of concept. I'm not talking of a delay by an individual speaker. Whether the Kerala speaker will decide tomorrow, a Nagaland speaker may take 6 months, a Manipur speaker will take, that's not the point. Conceptually, the logically prior decision has to be para 2, not a governor's intervention collaterally in any which way. That's the structure of the 10th schedule. And that scheme and structure must be endorsed and strengthened by your Lordships. Inter alia, by not accepting any collateral incursion horizontally sideways by a governor, while that 2-1 is still pending. So, the next facet of this is the processes within the Parliament and Assembly have to be allowed to work themselves out first before external intervention. And one of the important processes is to notify a confidence or a lack of confidence. If your Lordship is so careful about not even allowing repetitive bites at the apple to destabilize a government, your Lordship will allow an external incursion without even a single no confidence motion. I'm not repeating, I'm giving Lordship in addition the larger context. Not even an attempt, because as they say, the proof of the pudding is in the eating. If you have the confidence, move the no confidence. It's your lack of confidence which makes you not move the no confidence. Because you know how the no confidence will be met. And may the best man win. If you have the guts and the courage, do it. Whatever will happen, will happen. That's the process of democracy on the floor. Incidentally, when I've done the maths, that chart, I mean, it is not that your Lordship will only ask them to show the material. We are having a preliminary objection that the governor doesn't come into it irrespective of the material, even if he has seen the material. I am now on concept, I am on juristic principle. There is no role of the governor till now, till whatever I have said, 2-1, etc., process, no confidence, no role for the governor. It's a second separate question on facts, what the governor saw, did not see, but he had no locus to see or not to see. So what's the point of going into down that path, fellows? The governor had no locus at that stage to see or not to see. Well, it would really amount to a very strange thing where the governor would, well, governors are now, obviously, if you read the debates of Mr. Ambedkar and now there's a vast difference. But governors are also creatures of political connection. The governor would say, well, I see a group of people here. Why are you bothered about moving a no confidence? Come to me, we will see something. There's no need for us. The assembly gets substituted. You'll be circumventing and short-circuiting the entire process of a no confidence on the floor. Yes. But I'll just pause here. It has some very startling consequences. If your Lordship reads this, it's a constitution bench. It makes only one exception. When I, the speaker, by an interim order disqualify you, that has happened hardly ever, but it has happened once or twice. but it is not really happening in the 10th schedule. Maybe that will be a new technique adopted in the future, but I don't know. But today, well, hardly any case. But
you are giving the idea.
No, but Kyoto gave that idea. Kyoto has given the idea already, but that's why I'm saying from 92 till now, it has not happened despite Kyoto's idea. I mean, it may have happened one or two cases, but hardly ever happens. Yes, Kuldeep Bishnoi case, etc. But in that exception apart, it is per se jurisdictionally bad. So therefore, a perceived error of the speaker's conduct will not justify your interlocutory application. That's important. Let us assume that the speaker is wrong. Nobody is conceding that. Let us assume that the speaker is grievously wrong. That will not justify circumventing of a constitution bench by saying, normally we will not interfere, but here, by a matter of degree, I opine that he is grievously wrong, therefore we will interfere. Well, let's take an example. Your Lordship has applied that example for decades. It is not something strange at all. Kyoto was, according to me, saying the obvious in a much more important category. Your Lordship has done it for lesser category. Well, as your Lordship finds genuine problems in an election process. When an election process starts, your Lordship finds genuine cases. My nomination rejected badly. I was stopped at the door by a guard. I couldn't enter. Somebody obstructed me. I couldn't file in time. This man is rejected on a comma, full stop, wrong ink. They are very compelling arguments. Your Lordship says, come after the election. In 99% cases, unless there's a special statute. Because you don't interdict an autonomous, self-contained scheme of a code there to let elections go on. Here, a much higher constitutional authority to allow unfettered proceeding further. There are many more examples the Lordship has. Therefore, the position which by a combination of the positive and the negative order inevitably led to the change of government, possibly was also constitutionally wrong.
Nabam says, applying Nabam here, the speaker could not have decided. I mean, I'm not putting that against you, but I'm just trying to analyze.
As the principle today stands.
As the principle today stands.
Correct.
Nabam says that where a motion for the removal of the speaker is pending, he cannot decide the issue of disqualification. You say refer Nabam to a larger bench. But suppose you take this, that well, these 39, that Nabam therefore should not be construed to prevent the speaker from deciding disqualification.
Yes.
And these 39 were therefore liable to be excluded because the speaker would have been justified in hearing the disqualification, notwithstanding the pendency of the motion to remove him, that the speaker would have disqualified these 39 because, as Mr. Sibal said, it's a per se disqualification. It's a clear split. What is the ultimate consequence? That these 39 have to be taken out of reckoning on the trust vote which takes place.
My Lord is back to the chart figure.
Which these 39 have to be taken out of reckoning.
We have answered the governor point. Lordship is not coming to the governor. Governor is constitutionally barred. I'll deal with the chart in a minute. Well, today, can your Lordships proceed on hypothesis upon hypothesis? What would have happened had this happened? But I will satisfy that conscience also. Well, first part of my Lord Chief Justice.
Did you not really?
The governor could have acted on that.
Did you not preclude a consideration of this argument by your own failure to face the Legislative Assembly?
So there are 2 or 3 answers.
Because also, I'll tell you why, and we'll rise then and we can reflect on this at lunch. Because today, what you are really asking for, and we're not saying that you're wrong in asking for it, because first principle, the court said subject to the outcome. So therefore, we have to now treat it, if we come to the conclusion that you're right, then ignore all outcomes.
And my lords have done it twice in 10 scheduled cases of big moment, twice.
Fair enough. But before a constitutional court does that, namely to set back a status quo ante constitutionally, we must be in a position to say that, well, there is an arguable outcome which would matter.
Absolutely.
Which would make a difference.
Absolutely.